Hey there, legal enthusiast. Today, I'm diving deep into a hot topic: presidential power over visa revocation and deportation. Can the president revoke visas and deport non-citizens at will without judicial review? Or does the Constitution require due process? Let's break it down. First up, Congress's plenary power over immigration. The plenary power doctrine is a long-standing legal principle affirming that Congress has near total authority over immigration. The constitutional basis, Article 1, Section 8, Clause 4, which allows Congress to establish uniform rules of naturalization, and the necessary and proper clause, giving Congress broad discretion to legislate on immigration matters. The inherent sovereignty doctrine, affirmed in Nishimura Eikiu v. United States, states that the power to exclude aliens is inherent in national sovereignty. Key cases like Chae v. United States and Fiallo v. Bell reinforce Congress's absolute power to control immigration, while Knopf v. Shaughnessy holds that the executive has broad discretion in enforcement, especially in times of war. So, Congress controls immigration law, and the executive enforces these laws under delegated authority. The judiciary? Limited role in reviewing immigration policies. Next, can Congress block judicial review of visa revocations? Statutory basis, 8 U.S.C. Section 1201I, grants the Secretary of State broad power to revoke visas at will, explicitly stating no judicial review except in a removal proceeding. Key cases like Kleindienst v. Mandel and Carey v. Din affirm Congress's power to control admissions and exclude individuals without detailed explanations. The takeaway? Federal courts can't hear lawsuits challenging visa revocations unless within a removal proceeding. Congress has near absolute power to strip courts of jurisdiction in immigration matters. Now, can non-citizens claim due process in deportation? The Fifth Amendment guarantees due process, but does it apply to non-citizens? Wong v. United States confirms illegal aliens have some due process rights, but deportation isn't a criminal punishment, so fewer protections apply. Shaughnessy v. Mezei holds that non-citizens outside the U.S. have no due process rights when denied entry. The most important modern case, DHS v. Thuraissigiam, ruled that an alien seeking initial admission has no constitutional rights regarding their application. Asylum seekers facing expedited removal have no due process rights beyond what Congress allows. If a visa is retroactively revoked, meaning the alien was never legally present, due process doesn't apply because no legal status ever existed. Lastly, can a judge block executive immigration policy? Key cases like Trump v. Hawaii uphold the president's broad authority over immigration, stating courts should defer to the executive branch on national security. INS v. Chae struck down legislative vetoes but reaffirmed deportation as an executive function. A district judge doesn't have more power over immigration than the president enforcing Congress's laws. Nationwide injunctions are controversial and constitutionally dubious. So, has Congress given the president unlimited authority over visa revocations and deportations? Congress has near total control over immigration. The president enforces these laws. Courts have limited power. And if a visa is revoked retroactively, the alien has no due process claim. But here's the potential constitutional issue. Has Congress delegated too much power to the executive branch? INS v. Chae suggests Congress must retain oversight of the powers it delegates. However, modern immigration laws grant broad discretion to the executive, giving the president significant control over enforcement. Final thought: should Congress reassert control over immigration, or is a strong executive necessary for national security? What do you think? Let me know in the comments, and don't forget to like and subscribe. Catch you next time.